If my I-751 petition to remove conditions was denied, can I at a later date apply for permanent residence based on marriage to another U.S. citizen? I'm recording this video on this sort of niche topic because I recently won a case under this exact fact pattern, and I noticed in my research and just talking with the client that there's a lot of misinformation on this topic. And also the client had shared with me that they were advised by several attorneys that you cannot win cases like this, and that basically once your I-751 petition is denied, it is very difficult to apply based on another marriage or other avenues of relief. And I want to explain that there's a precedent decision that actually controls this fact pattern, and it actually kind of ties the USCIS officers' hands, in which they cannot refuse to approve these cases just because that I-751 was previously denied. Before I jump into all of this, thank you so much for tuning into the channel. I appreciate all of your comments, likes, follows. It's been truly a pleasure to record these videos, and I'm so happy that all of you are saying that they're helping you. My name is Adrian Pandev again. I'm an attorney who helps foreign nationals navigate the U.S. legal system. And again, my goal with these videos is to try to make your life in the U.S. a little bit easier. Now, let's jump right into this and discuss this topic. So first of all, what is an I-751 petition? An I-751 petition, it's called removal of conditions petition, is one that has to be filed after you obtain a marriage-based green card. So say you filed, your I-130, I-485 petitions, applications, you obtained a green card, you became a permanent resident based on marriage. If at the time that your green card was issued, you had not been married for 2 years, you will receive what's called a conditional green card. If you have children applying with you, so say you married your U.S. citizen spouse, but you have children from your previous marriage, if those children are applying with you, they will also receive conditional permanent resident cards. If you receive such a conditional 2-year permanent resident card, 90 days within that 90-day window before the expiration of that 2-year card, you have to file an I-751 removal of conditions petition. And what you're doing in that petition is proving that the marriage based on which the green card was approved was in fact a valid marriage at the time of issuance of that green card. So to make it very simple, basically before the end of that 2-year period, you have to submit evidence proving the validity of your marriage again. And just to clarify, because this is important, if you're a child, right, and you obtained your conditional permanent residence through the marriage of your parent, then this will apply to you as well, right? So it's not just a primary applicant, it applies to children as well who became permanent residents due to their parents' marriage. Now, what happens is, if this I-751 removal of conditions petition is denied, then USCIS sends a denial letter stating that, in essence, it puts you in a limbo because your permanent residence has not been renewed, right? The conditions have not been removed. And in essence, you can no longer prove that you're a permanent resident. On top of that, a USCIS can initiate removal proceedings by filing an NTA with the immigration court, which if that happens, an immigration judge can actually order you deported, order you removed from the United States. Now, what I've seen in a lot of these cases, and what brought me to record this video, is that individuals will receive the denial, so they will receive a denial of the I-751 petition, but then USCIS does not initiate removal proceedings, creating, in essence, a limbo where you have an expired permanent resident card, you have a social, you have all of these things, but you do not actually have any proof of valid legal status because you were unable to remove conditions on your permanent residence. But at the same time, also, you are not in removal proceedings. The government has not initiated removal proceedings, so you don't have an active deportation case. So you find yourself in this limbo inside the country. Now, what I see in these cases, very often the children who find themselves in this situation, who obtained conditional permanent residence through their parent, grow up, become adults, and later, meet a U.S. citizen and may want to file for a marriage-based green card or other green cards, and other categories of green cards. But the most common one I see is this marriage-based green card. And the big question that everyone has is, are you able to file for a new green card for basically under a new permanent residence category, even though you were a conditional permanent resident before? And I've read a lot of misinformation, like I said, about this, and even the client whose case we recently worked on had received mixed information. So my goal is to clear all of this up. So before I jump into exactly what the rule is today and how it can help in these circumstances, let me go into what the rule used to be. So these cases are actually governed by a precedent decision called Matter of Stockwell, issued by the Board of Immigration Appeals in 1991. And Matter of Stockwell changed the previous rule, which used to be that if you applied to remove your conditions and that I-751 removal of conditions petition was denied, you could not seek another basis to adjust status. So even if you remarry, many years later, or if you were a child and you obtained conditional permanent residence through your parent and you remarried years later, you could not adjust status. You could not become a permanent resident because your I-751 removal of conditions petition was denied. Basically, if your conditional permanent resident status terminated, you could not adjust again. That's what the decision was prior to Stockwell. This changes after 1991 because in Matter of Stockwell, the Board of Immigration Appeals stated that as long as your conditional permanent resident status was in fact terminated, so basically you received communication from USCIS that case was denied, you can in fact readjust status under a different category. You are not barred from readjusting status. The key reason for this, explained in Stockwell, is that INA, the Immigration and Nationality Act, does not bar someone whose I-751 was denied from adjusting status in the future. There's no particular bar. The argument the government used to make is that you're already a conditional permanent resident. You can't become a permanent resident again. You're already it. But this is where Stockwell changed how the rule is applied, because it held that if the 751 petition was denied and your conditional permanent resident status was terminated, well then in fact you can readjust status to that of permanent resident because you lost that status completely irrespective of whether or not the government initiated removal deportation proceedings against you. So where does this leave you, and what do you have to know? The bottom line is, if your I-751 petition was denied, irrespective of whether it was your marriage or your parents' marriage that it involved, that does not mean that you can in the future not apply to become a permanent resident again. You actually can, and Matter of Stockwell allows it. Now, there are a couple points I want to raise, and they're critical. If your I-751 petition was denied and you were the one who was, in the marriage, you were the principal primary applicant, and the government argued that you committed fraud and that you had committed marriage fraud, that could prevent you from obtaining permanent residence in the future, right? So Matter of Stockwell does not cure future inadmissibility. So you still have to demonstrate that you can in fact become a permanent resident in that future permanent residence application. So this is why I'm saying that often the primary applicant whose I-751 petition was denied has trouble filing for a new green card because they're unable to prove that previous marriage was in fact a valid marriage, which they need to prove in future immigration applications as well. Where I see Matter of Stockwell being extremely useful is cases where immigration frankly made a mistake and the I-751 should not have been denied, or cases where someone didn't file a lot of evidence with their I-751 petition and they could have filed a stronger case and didn't. And most importantly, children. I mainly see it come up with children where the parent may or may not have been in a not valid real marriage. So the I-751 was denied, but the child, it wasn't the child's fault. They were not the one that was, entering that relationship and filing those documents. And those children who find themselves in this position are truly helped and benefited by Matter of Stockwell, because it does not bar them from filing future green card applications, and they obviously were not the ones committing any marriage fraud in the past. So the denial of the I-751 should not in and of itself bar them from becoming permanent residents. So bottom line here is, just because your I-751 was denied does not mean that you can never again apply for permanent residence. Not at all. Be aware of Matter of Stockwell. I've put the link to the case and the USCIS website explaining it in the description of the video. If you have any questions or comments about this, post it in the comment section below, and I'll do my best to record more videos on this. I know this was a more niche topic, but I think it's an important one to know given what I had read and all the different comments and information I found online. I wanted to clear it up because it's a clear-cut BIA precedent decision that USCIS officers absolutely have to follow. And I think there's probably many of you out there who are afraid to file valid green card cases just because your parent or you had a I-751 denial in the past. If you have any questions, again, like I said, post them in the comments and I'll record more videos like this. Thank you for watching. Bye-bye.